So the question is, what does all this new testimony mean for the defense and for the state? Well, to help us better understand it all, I want to bring in Rachel Fiset. She's a criminal defense attorney, and Eric Bland. He's the Satterfield family attorney. You remember Gloria Satterfield was the Murdaugh family housekeeper who died after a fall in their home in 2018. It's great to have you both here. Eric, I'll start with you. The judge allowing the financial testimony to help prove motive seemingly all coming in. Were you surprised by this ruling at all, or is this what you came to expect?
No, good evening, Jesse. And no, I was not surprised at all. In fact, I'm one of the only television commentators right now that is advocating the good job that the prosecution is doing. And I've said on a number of national shows that I thought he was going to let this in. It will come in as motive. It will come in as to malice. Whether it's enough for the jury to feel that it's a reason for him to have taken the life of his wife and his son, that's yet to be seen. But Mark Tinsley is a very compelling witness. He is a hitman. You let him into your house, he will blow it up. He carved up Alex today like a Thanksgiving turkey. He's a brutally good attorney, and his testimony is compelling. I think Alex was under some significant financial pressures, more than the people realize. Also, he was the subject of a grand jury investigation for tampering with witnesses after the boating accident in the hospital. Sometimes problem solving is the way that killers get rid of problems. They have to problem solve. Mm-hmm. Whether we think that's a good reason why he got rid of his problems to get rid of his wife and his son, I don't know that. I don't know if it's going to carry the day, but this was a very bad day for the defense. The housekeeper witness was very powerful up to a point. I will tell you that it's quite possible that the blue jacket was inside the tarp. The blue jacket was inside the tarp. Remember, he went upstairs.
And I want to get to that. I want to get to that. I want to get to the tarp. I want to get to that other aspect. I do want to focus on this ruling for a second, because Rachel, this is the way that I see it. I think that there were certain things that needed to be let in. So if you tell me the CFO is going to come out and say that on the day of the killings, she was pressing Alec Murdaugh about this missing money, that's significant to me. That's significant to the jury. As Eric was saying, you have a lawyer that was suing the Murdaughs saying, hey, listen, if this guy was the real victim of someone coming into his property and shooting his loved ones, we're going to put this case on hold. I don't think it's going to work anymore. I think this lawsuit needs to settle. That's significant. I do think, Rachel, that this is something, though, the defense could use. I think that this ruling by the judge might not be so great for the prosecution because there's so much there, so many numbers, so many accounts. Is it possible this could blow back on the prosecution? It's just too confusing for the jury? Maybe I'm off. You tell me what you think.
I think the prosecutors have to do their job. They were just handed a Christmas gift, and now they have to figure out how to best utilize their present. So if they decide, oh, let's say everything, let's go deep, deep, deep into the financial crimes because there are so many and there's so much there, let's really talk about it. They may lose the benefit that they were just given by this gift. But if they artfully are able to tell the story to the jury and break down these financial crimes in a very palatable and skillful way, then this ruling is huge for them because it puts in the jury's minds over and over again, if it is given to them the right way, what a criminal Alec Murdaugh is. And that is their gift. They are given the gift of being able to tell the jury that he is a criminal.
It's so bizarre, Eric, right? I mean, to think about a man killing his family over this, for people, murder over greed, over love, over this, it's making more sense as the prosecution's putting it forward. But do you think, what does the prosecution have to do now? Like you said, like Rachel said, is it presenting it in a way where the jury can pay attention to it? I mean, some of this is dry. It really is. I know we're talking about a guy allegedly stealing people's money, but how does the prosecution present this in a way that helps them and doesn't hurt them, Eric?
Because they're going to be able to show that money to Alex was his God. Everything revolved around him being able to make a living from that law firm. He made it lawfully. but he also made it unlawfully by stealing with clients. And he knew that the Satterfield matter was an external threat to him, that he could contain whatever was in his law firm with whatever excuses and standing down Jeannie, the CFO. But the Satterfield matter was external. And once the article was written in the paper that there was a settlement and he had taken 3.5 million to 4.3 million, he now knows that there's other people looking for him and he could lose his ticket, his bar ticket. And for him, making money lawfully and unlawfully was it for him. And he knew that threat was now at a point where it was coming home to take it away from him.
So, Rachel, let me move on to you with this. So the defense says that it's going to ask the court to provide the jury limiting instructions. What does that exactly mean? Does it limit on what's going to come in or what they're really supposed to consider this evidence for?
It's what they're really supposed to consider this evidence for. And limiting instructions sometimes to a jury simply goes over their head. So what the limiting instruction looks like in plain language is you can't consider this evidence to show that Alec Murdaugh is a bad guy. So don't use it for that reason. You can only consider this evidence that he killed people for money. So this is, or to cover up his other crimes. Now, when you hear that as a juror, your head kind of explodes because, oh, okay, I can only consider it for motive and why he did this, but I'm supposed to erase the memory of everything that I'm hearing as it relates to other crimes, and that this man might have some serious questionable behavior and do a lot of terrible things to people. Okay, so I'm going to take that out of my mind and I'm just going to consider it for motive. So that's what the limiting instruction is meant to guide the jury to do.
The reality is,
you know, jurors are not human beings, right? They're really just easy, you know, they're not human beings. It's very so easy to separate that, Eric. I do want to go back to something. I'll give you an opportunity to talk about what Rachel just said, but I want to go back to the forensics as you promised, right? So let's talk a little bit more about the GSR of that raincoat. What do you make of it? Because again, that was one of the big highlights in the prosecution's opening statement. That, the kennel video, they chose to highlight that. What's your take on it?
Well, prosecutor has to deliver. If he's going to put it in his opening statement, he better deliver, or a good defense attorney like my colleague here will tear him up in closing arguments. So the key on this was there's GSR on the inside of the coat. There's probably going to be GSR on a raincoat in a country house that shoots guns all the time. But saying that's on the inside of the coat connotes that something was transported that released the GSR on an inside of a coat. And one of the things that has been posited by one of the listeners on my podcast, Cup of Justice, is that maybe the coat was balled up with some other things in the tarp, because she said, Miss Shelley, that he went upstairs and then came downstairs with the tarp and unfolded it on the mother's reclining chair. So the state's got some issues. I thought they had a really good, strong direct of Miss Shelley, but I think the cross-examination, she gave up a little bit.
Okay, so let's talk about that. Because, Rachel, I can't end this segment without talking about Shelley's testimony. Pivotal witness. She basically says that Alec Murdaugh, I don't know, tried to pay her off, tried to come up with his own alibi. 20 minutes doesn't compute with what he told investigators about 30, 45 minutes. But then on cross-examination, she kind of was iffy. She said when she first told investigators it was, what, 35, 40 minutes? Now she's saying it's 20 minutes. What do you think the jury's thinking about Miss Shelley's testimony?
I think she was mixed. I think her testimony was mixed. She started off strong for the prosecution, and on cross, she got weaker. And it's not so unusual. She's been a caregiver for this family, and she knows the family, and she doesn't think he's a bad guy. So it's not surprising, but I think if the prosecution can make hay of her testimony, they focus in on the benefits she was a little bit promised or suggested as it relates to giving the story that he wanted to give, and they focus in on him bringing in the tarp, and then the rest of it is probably not that helpful.
All right, Eric, I'll finish this off with giving you a question. I saw you on Cuomo earlier. I wanted you further to explain it. Do you think Alec Murdaugh has to take the stand now to explain this away? I think it's a terrible idea. I think if all this financial crimes come in, I'm going to think, why is the jury going to believe him now if he was that deceptive? You think he's going to take the stand?
No, he'd be crazy too, and his defense attorneys would be crazy to put him on the stand, given the holes that he's had with his alibi and the timeline. More important, to put him on the stand, he'd be subjected to the fact that he tried to muscle up on Miss Shelley and let her know that I can help you with your job at school and I can help pay for your wedding. And don't forget what Mark Tinsley said. Mark Tinsley went to him and said, if you tamper with my jury. So that's an example that Mark, who's in that area, knows that Alex may be able to tamper with the jury. It doesn't present the right kind of guy. It presents almost like a mafia strongman. I do not believe that he will take the stand with all of these financial crimes, because you'll end up convicting him of murder because he's the serial thief.
Yep. And I think the defense has some holes that they can work in the prosecution's case. I don't think it's necessary for him to take the stand. I've advocated before. Who listens to me? Rachel Fiset, Eric Bland, thank you both so much for taking the time. Great conversation.